Yeah, I think 7's where we stopped.
Yes, that's where we stop. Good morning, everyone. How are you doing? Back again for part two. If you missed it, it is recorded in this live stream. Just once again, wanted to introduce our guest speaker, the wonderful John Dodson, attorney. I love that in your bio you have a Texas A&M grad. That's obviously a big deal. And then owner of Ranchers Title Company. Just clicking through here real quick. Good morning, everyone. I see you in the chat. If you have any questions, please feel free to put them in that chat. And if we can get to them, we will answer them. We stopped off at 7. However, I think we wanted to revisit G7 because it was brought to our attention that there are now agricultural development districts. John, I did send you that information. One of our lovely agents reached out to me and she goes, "Hey, I actually have a deal. And here's the documentation. Is this an agricultural development district?" And I sent it to John literally right after the last broadcast last week. And he's like, "Well, don't you don't you know there are?" So, John, did you take anything away from that or anything you can add?
Yes, and I was going back here trying to look through that text. Yeah, so we found that in the Texas Special District Local Laws Code, Chapter 3001, which dealt with the Southeast Texas agricultural development in Chambers County. It's set up now, or it's statutorily created. Now, whether it's actually active or has been implemented, that's a whole nother question. That's a local question to find out. But statutorily, yes, it's there. And there's quite a few other areas in that statute. I should have had that printed out, but that's where you look is there in the Texas Special District Code, Local Laws Code of the statutes. So very interesting. And see, I always learn something from these things, and that's why I like to do them as well, is because you get so much input from across the state from people and their own experiences. So thank you for bringing that to my attention.
Well, I'm glad we made a little noise with our broadcast because it is important to stay in the know and have your finger on the pulse, so to speak. So very, very exciting to have everybody here. See some new faces in the chat. We're just going to get started. We left off at property conditions. John, if you just want to kind of pretty standard, but if there's anything that you want to cover or give some examples.
Well, I think the thing to note, and most everybody probably knows this, but it's always good to point out, is that you obviously have reasonable access for the agents and the part for the buyer, and inspections are allowed during that time. But hydrostatic testing, which is the testing of pressure, water pressure, must be a separate agreement. And I know that there was some issues with that just years ago. And that's why they separated out, because there were some issues with that's not really an inspection. That's actually a test of the property. So that's why they separated it and put it into a different agreement. And just note that and they specifically state that so that you're aware it's covered by another deal, by another agreement. Obviously, you got Chapter 5.008 of the Texas Property Code regarding that notice. It's required, or it may not be required. Now, when are some of these notices not required? Certainly, that one is not required when it's coming out of an estate, because the person really is not required to have any knowledge. They didn't live there. They didn't own the property until all of a sudden they inherited it, right? Especially if it's coming out of the probate, right? The seller is the estate of John Doe. And
so I want to touch base on that because we have agents that come to our Texas broker room, and it is a trust. However, it was their grandfather's ranch and they lived there and they were just there for Thanksgiving and they know the property condition. So in that definition and understanding, it is an estate and went to probate. However, the person that owns it now does have all that knowledge. So should we as agents recommend, because they are aware?
I think if they are aware, and that's why I was trying to be careful there, was I think if you're in a situation where the decedent is fairly recently passed, within a year or whatever, and now we're selling the place, and I've seen it more in residential, because typically, mom and dad pass, now the kids have the house, nobody's living there, they just need to sell the estate, boom, boom, boom. You're not going to have any of that knowledge. Now, I think it's best practice, probably practical, is if you have the knowledge, go ahead and fill it out. That way you kind of cover your base as the seller's party, and the buyer then has as much disclosure as possible, right? But if you don't know, you don't know, and you disclose that. So, but I have had some pushback on a file or two. It doesn't happen very often. So, all right, let's see. Obviously, pretty straightforward property condition, as is most of the time. I like how the contracts have gotten better about being more explanatory, certainly in section 2 there of D, where it says you can't put general clauses in there. You be very specific about what repairs are going to be done. Now you notice they've made some changes. They added the word "and treatments" to section E. And then they added that the requirement to obtain any permits, which, depending on the area, you're not going to have that in your more rural areas, and certainly closer you get to the metro areas or the more sophisticated or populated counties. Yes, you still have rural land, but it still may be subject to the ETJ or the extraterritorial jurisdiction of the city, or the county may have some regulatory requirements that must be met for building. But you're not going to see that in Uvalde County. You're not going to see it in Coke County or Reynolds County or somewhere out in West Texas, or in some of these some smaller East Texas counties too. Just depends on the county. But that's a practical matter there. Now, of note, the other addition is that sellers shall provide buyer with copies of the documentation from the repairs done, showing the scope of work and payment of work completed, and then sellers required to pay for any transfer or warranty fees. So that's a new one into the farm and ranch world that we haven't seen before. And then they must be delivered at closing. So, and then obviously the buyer has a choice. If those aren't done by the closing date, they can either exercise their remedies of 15, which deals with, that's going to deal with cancellation or default of the contract, or they can extend in order to have those repairs completed to their seller.
A little more due diligence for us on our end.
Yeah. So I foresee that being a potential issue if you've got a property where you've negotiated some extensive repairs that don't expect to, as a practical matter, to hit your closing date, possibly, just given the state of contractors in general in the state. And certainly more last year with the shortage of supplies, and any good contractor worth their money was booked out for 6 months. I had the personal experience of finding one that wasn't super busy, and I learned that I knew better. But anyway, that's a story for another day. Just be careful. You're all probably familiar with lender required repairs. That happens in the housing world too sometimes. Residential, I mean. Let's see. Environmental matters. Paragraph G. There's an addendum if you've identified any potential matters regarding that, and those addendums are covered in the contract. Later, those attachments, and you go to TREC and get those depending on what your particular issue is. Again, depending on what area of the state you're operating in. If you've got more wetlands issues in northern and eastern part of the state and the drier parts of the state, you might have certainly the older the ranch, you might have old dumps or things to deal with, and those come up and are covered under G there, and their particular addendum that goes with it.
And you know what? Something I've notated. Some of the farm and ranch groups, especially in my area, the hill country and down where you're at, we deal more with CWD and then also out west anthrax. Would this fall kind of under this category?
I think if you've got that, I don't think they have a form for any of that yet, do they, Lindsey? That I'm aware of.
They don't have a form, but certain brokerages have created their own form with their attorneys.
Correct. I've seen that with oak wilt, which is a disease that affects live oak trees, and that's obviously a big issue in Central Texas and South Texas too. It's not as much of an issue in South Texas, but the Hill Country area, Central Texas area, that's a disease that I've seen those disclosures. I have seen a disclosure, a homemade, it probably drafted by their brokerage's attorney, possibly, to deal with those issues that might have CWD or anthrax if it's a recreational hunting property like that. So again, those are just trying to protect that seller and deal with disclosure issues on the property. So
actually used that one for a buyer in not South Texas, but closer to Rock Springs, where, didn't know much about the anthrax, and educating that particular client. So I used that form, obviously, so she could go on and get with a biologist and learn a little more about what that is in agriculture and how it affects not just agriculture, but wildlife.
Right. No, very good point. And those are just the issues I'm aware of in this part of the world too. There may be others out there that may be more of a local type thing or regional issue. But obviously some brokerages have decided it's enough of an issue that they wanted to come up with something to give to the clients, which I think is smart. So, all right, moving on to H there, again, disclosures.
This is the new section. This is we've already had a handful of questions because most of the time when you write a contract or an offer, it's written by the buyer's agent and the buyer. So participation and communicating, obviously the buyer's not going to know these check boxes or the agent. So kind of now we're working together to fill out this puppy.
Yeah, I think it's more or less forcing the seller's agent and the buyer's agent to communicate when the buyer's trying to draft that offer and say, hey Lindsey, can you tell me about flooding on your client's property? Is there aware of any of these, check these boxes so I can fill this contract out. So that helps, I think, in a practical sense, helps the buyer's agent check those boxes, right, and go through those questions so that they've got disclosure for their client. And it also helps both sides, I think. Keep in mind that the committee that drafts these tries to be fair, right, to both sides, where as much as possible. And generally these, as far as the outs go on these contracts, they're generally favored for the buyer, but they certainly try not to impose too much or try to help the seller with any potential liability points, right, with disclosure requirements. So I think it's a good thing in my book. Is it going to make you have another step? Yep. But everybody's got more information there too. And your due diligence. A lot of that, the floodplain stuff you can look up online. The FEMA maps, they're very easy to read. They're very self-explanatory on what a flood zone A, X, R, and they tell you those things. That kind of stuff you can look up. The rest of it, that's on the ground inspections and what you see when you go tour the property. You're just going to have to keep an eye out, for that kind of stuff.
I thought it was interesting. Obviously flooding is one. 2, pending threatened condemnation and special assessments, I believe it says, affecting the property. I thought that was a pretty interesting ad.
Yeah. Yeah. So potentially counties, somebody's either maybe a pipeline coming in with a common carrier that's thinking about putting in a, oil and gas pipeline or any other type of pipeline. That could be condemnation, obviously any governmental entity too, as well, for a new highway, county road, whatever. And any special assessments, those are going to be, obviously a property tax that's not your normal deal. You're in a little particular taxing area of the county for some special district.
It's interesting that not to interrupt, but it's interesting you said that about the pipeline, because we had that happen here in the Hill Country, through Blanco, Johnson City, Fredericksburg, in these counties. And, interesting you said that, because there were people from out of town buying, Hill Country property and had no idea that the pipeline was going to come through. And so I could see where this would be, very heavy handed to assist in that. I do know some people who actually were affected by it and were very disappointed, that they didn't know that information.
Real quick, while you were talking, I was checking the chats there. Elizabeth Primo from Chambers County missed the part about what I said there. So just to cover that, Elizabeth, so you heard me. We found out that there is a special agricultural district created in Chapter 3001 of the Texas Special District Local Laws Code, and it creates a agriculture district in Chambers County by its wording. Now, whether it's actually in existence is an inquiry that needs to be made at the county level. I have seen that in the past, just in my legal experience, where the state creates something statutorily, but either it was created and fell out, or it never was created. Somebody had great intention, but the actual implementation of that statute has never been done. So, and I believe the reason that ag district box has to be checked, because they potentially can impose a tax. So probably easy way to find out is just check the tax, the property tax records, because they list school district, county, city, any other districts that are imposing a tax will be listed on that property tax statement. So now back to disclosures. Obviously, Oakville, it's a big enough issue. They've now put that in as number 8 under H there. So now they've included it instead of brokers coming up with their own disclosures. So that's interesting to note. And then they obviously give you room for any other, if seller is aware of any of the items above, explain. So if you check yes, I believe you're just going to have to explain in that line or attach a sheet. I believe there was a question about any forms. I don't believe there's any forms. You check them out. I always have to go back and check with TREC when I'm looking for these forms to make sure I've got all the ones I need in a particular situation. But obviously they want an explanation, and they give you room or tell you to add a sheet or put it in that line there to describe those issues. All right. Residential service contract, everybody's pretty familiar with those. However, they put a requirement in here that the provider of that contract must be licensed by the Texas Department of Licensing and Regulation. So I guess they're cracking down on unlicensed and trying to regulate that residential service contract business.
Just to go back, John, real quick, I know that Oakville definitely affects the Central Hill Country, and I know it's spread to several other counties. I actually just pulled it up. 76 counties in the state of Texas now have evidence of Oakville. So I could see where that definitely is getting added as a disclosure to individuals, because we get people that come here and they buy something, they buy a piece of land because there's beautiful trees, and there's no guarantee those trees are going to be there.
Exactly. So, and we're all experiencing especially those of us that lived in Texas most of our lives, we're seeing a lot more people from out of state buying property in Texas. So I think just for practically speaking for realtors, the more you can, the more these contracts can help y'all get, and educate your clients. You know what I mean? Especially if you're a buyer's rep and having these folks come out and they don't have any clue. Uh, I'll give you an example of just the lack of knowledge that people seem to exhibit, but yet we'll spend a lot of money on property. Is where I've bought some property in Weatherford, Texas, in this subdivision, and there's that country up there is either you have to be on a well. I mean, you either have to have a well, or if you're outside the city limits, you're on a water district, and that's all surface water mostly around that area. And but this developer is selling at 2-acre lots, which is a minimum for wells and septic. And there's people buying that property for high dollar, and they're putting $800,000-900,000 homes on them. And they're pouring a slab and getting sticks on it, and then they come in and drill a well, which just blows me away. That people just expect to poke a hole in the ground and get water. But you can translate that to not knowing anything about wilt, not knowing anything about other issues that arise on these rural properties. So you guys are their best advocates and their best information out there on that. So if you start getting into the rural market more and more, which is a great market in my book, I love it. Then just those are some practical things that you can pick up and learn along the way and to look out for. So what else, Lindsey?
So true. I was going to chime in on residential service contracts. I know it sounds a little crazy. We're talking about structures and homes. However, there are some residential service companies, specifically one that our company is partnering with, America's Preferred Home Warranty. They actually cover some parts of septic and wells. So just a little highlight there I thought was neat. Also, multiple units. I know when we sell a big ranch with a lodge, there's a foreman's house, things like that. So don't, just because you're selling a ranch, a rural property, don't overlook this section. I have, thanks Hallie. Hallie's used them in San Angelo before. I know that when it was really busy, the strategy was like, don't ask the seller for anything. However, you close a deal, client gets in the house, guess what? Something breaks. And, it just, I've learned that it helps, diffuse thinking that, they purchased something or having that buyer's remorse. And it can be something very, very simple or very expensive. These companies actually are helpful. So highly educate yourself on the options that these home warranty companies have for rural properties. And that's something I've learned in the past few years with some of our partnerships. And it's been very helpful.
And just to add to that point I've lived in the country most of my life. And, what you don't think about is most water in Texas is going to be pretty hard, well water. So when you get into a property, a ranch that's got existing structures on it, and I've seen it happen more than once, is you're liable to lose dishwashers, you're going to lose water heaters, you're going to lose all those things that these residential service contracts can cover. And, if they don't have a water softener system or some other type of good treatment on those items can go out within 2 to 5 years sometimes. And so I agree, they're super handy, and don't overlook that. I see those contracts come in my office and they're overlooked and they don't address those. And just one more detail that can make the difference for both parties. I agree, Lindsey, that hey, seller's covered. There's no bad blood when it does happen. That service contract takes care of it. So
and I always remind, sometimes we get in this industry standard, the seller pays or the buyer pays. And sometimes I just, I have to remind my agents when we're in the broker room is listen, if you believe that this is something your client needs, however, the other party is not going to pay, or you don't want to ask them, negotiate that in because you're having to put in a very aggressive offer, which is something we saw last year. offering to gift it to them at closing. So just be mindful of that. I did have some scenarios where there was some buyer's remorse, and the agent went back and was like, there was like 5 other offers, and the reason we didn't put it in there. And just thinking, hey, even if the other party's not paying for it, that may be an option to where you tell your client, hey, you might need this. So don't overlook that section. I'm glad we got a chance to talk it over, because it is overlooked in farm and ranch quite a bit.
Yep. Very good. Okay. How about we move on to government programs? Now, if you haven't, we don't, again, I think we said this in the first broadcast. We talked about, most of the properties we're seeing, at least a good portion of the state, you're seeing recreational, right? You don't see a whole lot of quote farmland trade unless it's going to get taken out of production and developed into houses, which is the more common thing I see. But government programs can be an issue, certainly in productive areas. If in certain areas, certainly in the farming world, they could be dealing with USDA on any of the various programs they have. But some ranches can qualify for that too, for brush control. If they're working with FSA or USDA through their programs or EQIP programs. So if any of those things can be transferred, or they're subject to requirements of continued operations, if it were to sell, certain practices, that's where you would plug in those disclosures on those government programs. Those are the type of things that might come up under that. And generally, because you're receiving payments for doing those things, those type of activities on the property, whether it's flood control, brush control, soil erosion, and there's lots of different things that could fall under that program. So be sure you inquire about that.
Great stuff to think about. Standard number 8, obviously, if you are related or acting on behalf of a relative in this deal, letting individuals know that you are a licensed real estate professional.
Yep. And then, of course, all your broker fees are contained within separate written agreements, which is pretty standard. Closing date, everybody knows what that is. Everybody likes to be, a week from now. I understand. I'm going to I'm going to grapple a little bit as a title company, but no, we like to turn them around too. Obviously, if we don't get it closed, we don't get paid either. So we do our best on our end, but it's difficult sometimes in these more rural areas. This is not, they're larger tracts. You got more parts to these deals in a lot of times. Certainly if it's coming out of an estate or any other entity, potentially, you got a few more parts to the deal, and it takes a little more time. It frankly does. Lot and block, we can turn out in 2 days, 2 to 3 days on title, and have you closed especially on a cash deal, we can have you closed in 10 days, 7 to 10 days if we can fit you in our schedule too. But the title's usually pretty easy on that, all things being considered. But you get a real property that's a couple thousand acres and hasn't changed hand in 50 years, I guarantee you it's going to take a good 15 or 20 days to get that commitment out, just because of all the abstracts you got to go through as an examiner and look at it. So be sure and keep that in mind when your parties are when you're out there promising a fast close on a rural property. You better know your background as far as, hey, you got a prior policy. That's great to provide to the title company. I guess I'm speaking to the listing agent here in that respect, but any prior work that's been done on a property is very helpful that you can provide with the contract when you submit it to the title company. So keep us in mind when you're putting that closing date on there. Is all I'm asking.
You know what, John, this offers a really good opportunity for you to give us some insight, examples of what type of relationship you like to have with these farm and ranch brokerages and brokers. I know that I have learned to be very transparent, to keep you in the loop. even to do my due diligence, even before I take a listing, hey, let's pull title, let's get it market ready, trying to get, trying to get all that resolved. Can you kind of give us some advice on, how to connect with a title company and to be their buddy to
Right.
make sure that you stay out of hot water with your title company who's helping you close the deal?
Sure. As you all know, we're supposed to be the neutral third party and all that mess, but at the same time, the more we know about the deal, the better we can serve you. Sometimes, if so, as my wife, who used to sit in the escrow chair, would say when she talked to a broker, you say, "Okay, now tell me the story. Tell me. Let's hear what you know. Yeah, I don't need to know all the details, but tell me the story of this deal. What's everybody's attitude? How can we best serve you?" So the best way we can serve you, and my escrow agents can serve you, is knowing a little bit more about the parties. If we've got some unique circumstances, because we're going to run across that particular seller that's got some, has a certain attitude towards things, and you're going to run across certain buyers that way. So the more we know, the better we can serve you. And that's just a general comment on that. So we try to differentiate ourselves on that in the way we service our clients and customers by trying to be available as much as possible. It's certainly, when it was crazy, it was difficult to do that, and everybody was super busy. But now things have gotten a little more reasonable pace. It certainly helps us to know. The more we know, the better we can serve you. That's what I can add to that, I think.
Thank you so much, John. And, for those that haven't got a chance to go back and watch the original, the part one, John is the owner and attorney of Ranchers Title, which is, I don't know how you would say it. I'd say it's like the sister company to Garner Abstract and Title as well, and providing that level of service. So just wanted to let you guys know in the chat, I put a link to their title company if you'd like to check it out. They're one of our preferred. We like to let our clients know that they have the option to choose what title company they'd like to negotiate with the party on the other side. And here's a list, and Ranchers Title has been given quite a bit of street credibility and 5-star reviews for their handling of these ranch deals. So thank you for that.
And just to add to that, one more thing is, when we say we want to know more about the deal, but also if there's somewhere where we fall short, and we're gonna, I'll be the first to admit, I'm a human being. We're gonna drop the ball. Hopefully not, but we're gonna make a mistake. I don't want ever any of our, certainly our preferred partners, or people who want to partner with us, is I want to be as transparent as possible, as you said earlier. So if we messed up, I need to know it. I don't want you holding a grudge or saying, just complain. I need to know about it, or I can't fix it. So I like to have those open discussions. If I see there's a foul up, I like to bring it up and say, hey, we missed this. Let's fix it. Let's work together to get it done. And I would want that back on our end as well. So that's what I like to ask folks to do, is give us feedback, good or bad. I'll take the bad if it's there. Hopefully it's not, but I need to know about it. I don't want to don't want that mistake to happen again. So I appreciate that from Lindsey, and we've got another brokerage or two that we work pretty well with, but obviously I look forward to working with as many new folks as possible, because it's good for all of us.
Absolutely. Well, going down to 10, it looks like they didn't change anything in that one. So possession upon closing and funding, or according to the temporary residential lease. I think we are all good there.
You're liable to see a lot longer lease on a farm and ranch sometimes, just depending on what you got. And don't forget that, and I think maybe it's covered later down there. Maybe it's not. It should have. Anyway, if it's not later, I'm going to go ahead and mention it here that, sometimes you're going to have crops. If it's a farm, if there's anything to be harvested off there, you have a potential that seller, they might go ahead and close it, but that seller has a right to harvest some crops off of that. Maybe that's earlier in the contract, but that may be an issue where that would want to come up. But if there's any rights, if that seller is going to retain any rights for access and use of the property, be sure and use that lease, that temporary lease back. So also note in 3B3 that they've included the transfer of any warranties on the work or repairs that was done or anything else that might be warranted that's transferring. And then they've added in Section 5, the private transfer fees that are described in Chapter 5 of the Texas Property Code are responsibilities of the seller unless you've negotiated that otherwise. So sometimes you're going to see these where they've cut these properties into ranchettes, but they have, I call them ranchettes, they have a property owners association that's might require a transfer fee. So they address that. So you're seeing some of that residential contract language coming into the farm and ranch contract, which is interesting.
Yeah, it's funny. They call it a POA instead of an HOA, but there's still some the guidelines there that are similar, and I feel like it was under the radar for a while. So they're definitely bringing that to light.
And then we've also they had this a while back. We're going on a possession, but obviously closing and funding and that lease back. I kind of jumped ahead there. Bold highlighted there that you need to consult the insurance agent prior to change of ownership because you got issues with coverage on insurance when it comes to leasing things back. They've added a few years ago. They added in the issue or the statement about smart devices because now even these more rural homes, certainly there's some nice homes on these ranches. They're going to have a lot of the amenities that you might find in a nice home in a subdivision. So they addressed that there. Now they've reworked the warnings on the special provision. I like to call it warnings because I'm sure you were all taught as agents that this is a no-go zone, right? Because
yeah, right. Your pen will blow up if you write in this section.
Right. So that's pretty self-explanatory there, but I guess they felt it was necessary to go ahead and rework that because obviously the prior language was not acceptable to the committee. So it's pretty self-explanatory, but it does say real estate. There's your reminder. Brokers and sales agents are prohibited from practicing law and shall not add to, delete, or modify any provision of this contract unless drafted by a party to this contract or their attorney. So there you go. They put it in black. It's in blue here, but it'll be black and white on that form.
Literally.
Anyway. As an attorney, I'm very, very careful whenever I bring anything to this or make any other modifications that I feel may be necessary to this form, because I'll use them on some deals, most deals. But like I said, we do some complex transactions, and I've got some more complex contracts that I use for that in my repertoire. So 12, nothing's changed there. That's good information for your buyers and sellers to know what they're paying. It helps you kind of be able to explain that to them. You're going to see some VA loans out in the country or Veterans Land Board. You'll see those on some properties. We do those every so often here. I'll see them a couple of times a year at least, if not more.
Well, and I will tell you some of the updates they've made to VA. Before there was a limit on acreage, and now they have no limit on acreage.
Yep.
Now, mind you, it has to qualify and appraise and all that. However, if there's a residence on it, with 80 acres, and it qualifies, vets can now do that. I don't remember what the cutoff point was in the past, but yeah, we are seeing more and more VA loans. And then also they've upped the threshold. Normally it wouldn't go above like 460, and now you can see some, depending on the veteran and rank and things like that, you're seeing very large VA loans, surprisingly.
Yep. I saw one not too long ago. You're right. So keep abreast of those rules or be familiar with them if you're going to be in that situation. Well, where do we want to go next, Lindsey? Let's see.
I think we can go down to 13. I'm sure you've seen some issues of rollback taxes. I know nobody wants to talk about that and they want to look the other way, but I've seen it substantially affect a property deal because the amount of taxes, rollback taxes, and prorations.
Right, and just as a practical matter, it's becoming more of an issue. I've been doing this, been a lawyer over 20 years, and those rollback taxes weren't much of an issue in the areas I practice, but we're seeing it now where you're getting these rural properties, certainly to your metro areas that are high growth, where these these 2, 3, 4, 500,000 acre places are being bought and being cut up. Or I see some people who are trying to venture out and do that don't have that experience, and they don't pay attention to that fact and might get surprised by rollback. But it's becoming more popular, not popular, more frequent, I guess, in my experience, that rollback taxes could be a real issue on the sale of some of these properties if they're going to change the use. So, but back to the changes to the form and prorations, they've included rents, which you're more likely to have potentially on a ranch or farm where there's a tenant leasing for grazing, cattle, sheep, whatever, or farming, or any other agriculture use. And then regular periodic maintenance fees was added, and then dues, including prepaid items. So made a little change there on that. We've talked about rollback taxes. Anything else on that, Lindsey? I don't think so. Casualty loss, that hasn't changed. Talks about properties destroyed. Thank goodness I don't see much of that. Where we have a fire, some major loss that we have to extend or cancel the contract, or transfer the insurance over. Default paragraph, you've got specific performance by the seller or termination as an option, and the same for the buyer if the seller fails to perform. And then, of course, mediation, encourage mediation. Attorney's fees. Again, for some reason, they felt the need. We need to capitalize escrow agent, and that's pretty much all that happens in section 17 and 18. And I have no idea where that came from. I need to find somebody who's on that committee to ask them what the big deal was with that. But so since I am a title company, and this is important disclosure, basically to remind everybody of what our role is for this in this process, and with respect to earnest money and what our responsibilities and duties are, and that we may require for any disbursement. And we have good funds, which I'll point y'all to. Usually it's disclosed on Schedule C what good funds are, but y'all all probably know that.
We're not buying in crypto. Is that what you're saying?
Not yet. I think there's been a push for blockchain and title, and they're talking about trying to make that good funds too. So
yeah, I've heard as well that we get that question every now and then.
Yep.
What's funny is I know sometimes we get lackadaisical and just kind of roll over some of these rather quickly, but I think it's a great opportunity to walk your clients through responsibilities, especially since this might be the largest purchase they make in their lifetime, and they don't know the ins and outs and who's in charge of what and what all the moving parts are doing and things like that. So I do like this. I had a few agents come to the office. They're like, why did they capitalize escrow agent? But I think it's a good change because y'all are important. You should be highlighted.
Absolutely. Well, I'll take that. Thank you. I do want to point out that, it comes down every so often. We get this issue of contracts got to cancel for some reason. And then we get in a fight over earnest money and, who has the right to that. But just remember that when you're representing your client and you're doing your best to represent your client, that if we're requiring a written release, it's because we have to make sure that we have a duty, because we're in the middle, to make sure that money goes where it's supposed to go. Otherwise, then we're on the hook for failing to make sure both sides are appraised and aware of what's going on. So, fortunately, at some point that gets resolved. But believe me, we don't want it. We don't for whatever. If it happens, it happens. Y'all, we want to just make sure that we get the money to the right place. Now be aware that it points out in here. Now, I've never done it, but we can deduct expenses from that, and then excess to be refunded to the buyer on the earnest money. So, but rarely do we do that. So, and they have to be authorized by the party. So, so if you have us order a survey, or you've ordered a survey and it's come to us or come through us, which I don't like to order surveys, but if you ask me to call Smile Surveying and Uvalde and provide them the information, and then you follow up with a phone call, then I'm kind of involved in that contract, in that situation. And I don't mind doing that as long as it's in an email. But we try to stay out of that business too. I know some companies do, but I don't think it's a good practice from our end, because now we've gotten involved. But if we've got some written direction on it, you bet I'll help you out where I can. C is pretty self-explanatory. Lots of shall language in there. There's written demand period for the earnest money, and be aware, if only one party makes that written demand, the escrow agent shall promptly provide that demand to the other party. I'm sorry. Now notice, they've taken out the requirement that what happens if we don't receive a written objection. If the escrow agent does not receive a written objection to the demand from the other party within 15 days, we may disperse the earnest money to the party making demand, reduced by the amount of unpaid expenses. So, that were incurred on the party receiving escrow money, the earnest money. I'm sorry. So that's an important paragraph, and so these things come up. I always go back to the contract and reread anything that might apply. And I think I may have done that with you, Lindsey, once before. We had an issue come up, and I said, well, let's go back to the contract and let's walk through, what it says and what the facts are on the ground in your situation, and try to work through there. So we don't ever like to play in this paragraph, but it happens. So and obviously it's important, or they wouldn't have they wouldn't have spent 1, 2, 3 paragraphs, 4, 5 paragraphs on the issue, right? So A through E.
And absolutely, I mean, if you think about it, farm and ranch, sometimes those earnest money checks are rather large.
Yeah, they can be 100,000. I've seen them bigger than that. So there's a lot of money out there. So then there's damages paragraph there. That's what can happen if they fail or refuse to sign a release acceptable to the agent within 7 days of receive the notice. The potential for damages are there. And then obviously any notices that we are involved with will be effective under 21, which is the addresses and name and phone numbers were sent there. Now, and that's right below that.
I actually kind of like this. It makes it very clear that everybody's keeping in touch and everybody's, I know sometimes the title company gets a random email with a contract. I like to communicate, but sometimes it's like, hey, send it in. And, it's like, okay, who's what, who's on first, what's on second, what's going on here. So I like the transparency there on also the agents when they added that.
Right. All right. 19's pretty standard. We need to get rolling here. What do we have? About 10 minutes left, Lindsey?
Yeah, about 10 minutes. I mean, we can run over, but.
And then, so just says seller may continue to sell the property and receive any backup offers during that time. Federal tax requirements. This is a foreign person deal. If the seller is a foreign person, the buyer has a duty to withhold from the sales proceeds an amount sufficient to comply with any taxes that might be imposed on that. Now, as a title company, we always run, we're required to run the parties through the, there's a database that we have to run them through and check for foreign status. And if you have that issue arise, title companies should notify you if you don't already know it. And then they have a process we have to go through to withhold those funds. Notices, be sure you get good emails, good phone numbers, good addresses, because if the, what hits the fan, and we've got to get into the notice part of this contract, you want to be sure that you send it to the right person. Now, also, they've added in here a provision or line for a copy to the buyer's agent and a copy to the seller's agent. So be sure you got good contact information there. And I think that just puts everybody on notice that, hey, if you're going to send a notice to either side, be sure you send it to their agent, right? And I know, practically speaking, you agents probably end up sending that notice to each other and expect that it's going to go to the buyer. But just as the lawyer in me says, you know what, the contract says send it to the seller, send it to the seller. Or it says send it to the buyer, send it to the buyer. Yes, the agent is their representative, but at the same time, we don't want to get into that agency discussion in trial and the laws of agency, which nobody wants to hear all of that discussion right now. But so I'm glad they've beefed that up a little bit to include the agents in there.
Well, and I tell farm and ranch agents, take that industry standard of residential contract writing, and remember at this point, you have an executed contract, and if you're doing notices, the title company has already grouped everybody in a group email. So, good point to that in the notice side.
Yep. And then you've got, I think, all of your addendums in 22 about the agreement of the parties. I think, if I'm not mistaken, I haven't sat it down and compared them to a residential, but I think they're pretty much the same.
I believe so as well.
Yep. And then
this is where I put your name, John.
I like it. Just be sure that give me a heads up so we can visit with whoever it is, the buyer or the seller, and I can establish that relationship with them so I can represent them if I can.
Yeah, I had that talking to you guys. So don't just put the attorney's name in there, and the first time he's hearing about this is when you send him the contract and it's already executed.
Yeah, really not much I can do after you signed it. So thanks for bringing that up, Lindsey. So and I know, again, I'm not out here soliciting business. I'm just saying don't do that to your attorneys, or have somebody do that to your attorneys, and most good real estate attorneys I know are not here to kill the deal for either client. We want to make sure, though, that they've checked all the boxes on the legal side so that they're not exposed to any potential future litigation or liabilities. So if you get us involved earlier in the process, we can walk you through that and try to partner with you on that, because I am by no means any guy. I do not want to be out there showing property. I mean, I like going to properties, but I don't. You guys are great people. So, and that's why you're in this business. So you get that connection with those folks. I'm here to help you hopefully get through the legal side of it so we can get this deal to a clean closing. Notice in 23 though, they changed it from license holders to brokers and sales agents. I guess maybe they just felt that license holders was too broad. Wanted to narrow it down a little bit, but I don't know what the difference is, frankly. So, and that's about it. We're seeing, and I'm gonna make a comment here. There's no change really, but on the broker fees, you know, the area where you guys get to haggling over sometimes, and don't like to disclose sometimes. I'm seeing more and more brokerages bringing in that that part at the bottom. Do not sign if there's a separate agreement and payment of broker's fees. So, you know, I'm seeing more of the brokerages sending us that their statement for their fees as a separate document, you know, to the title company, and that's great. Just don't leave it blank and expect us to get it right on the settlement statement, you know, when the first draft comes out if we haven't received anything from you. Okay, as a practical matter. But I'm seeing brokerages getting more sophisticated and getting that information up front. When I first started, that was kind of an issue we would have, and people would kind of gripe at us. Well, I'm like, well, it was clear as mud on that page because neither one of you checked a box or, you know, or didn't put anything there. So because you didn't want to know what the other one was getting paid, I get it. It's fine, but just let us know on the side, and we'll keep it confidential. I promise.
Oh, well, I wanted to ask you, so best practices, we told agents, you know, either fill out the ratification on top or fill out the you know, lined out commission on the bottom, but don't do both. Is that still an industry standard?
I think so. That's what I'm seeing. Yeah. Do one or the other, but not both. Yeah. So very good. What else? Let's see. Yep.
I think that's it. I mean, that's pretty standard receipted contract.
Yeah.
Nothing's.
They added that option fee, and they changed this up a few years ago, but where they separated out the contract and the earnest money, they kind of had it all lumped in at one point, but when they broke it out. So we've got more room to sign those and get those back to you depending on the situation. So, because sometimes we don't get, you know, we may get the contract signed, but that earnest money doesn't. And everybody wants, you know, the brokers want their receipted contract, right? Because they got days they're clicking here, right? The earnest money coming in. They want to know that we've got it. So now we've got that area where we can sign it. We received the contract on today, and then we may not get that earnest money for 3 days, and then we'll sign that earnest money receipt 3 days later and send that out or whenever it comes in. So that used to, it was more lumped together. So
yeah, very, very clear on when delivery was made.
Yes.
Awesome. No, thanks for pointing that out, because I've noticed some of these changes I actually haven't really reviewed in depth, you know, especially since you guys are normally handling the receipts and things like that.
Yeah.
Well, John, thank you so much. You right on time. Just on behalf of everyone, we just appreciate you and everything you do for our industry, and obviously the services you provide my clients. I can't say more, but thank you for taking the time to do this and really help all the agents out there. And like I said, shout out to John, y'all. I put in rancherstitle.com. Definitely, I highly recommend him. He's got 5 stars from our group. But thank you so much. And is there anything else you want to say, John?
I just thank you for this opportunity to speak to everybody, Lindsey, and I always enjoy working with you, and I value our partnership in this industry and in this journey we're going through. And so thank you all for joining in on us, and I hope to get to meet you all at some point in the future down the road. If I can ever help you, let me know.
Absolutely. Thank you so much, John.
You bet. Have a great weekend.